Major breaking news. A lawsuit has just been filed by several Second Amendment organizations, including the National Rifle Association, the Firearms Policy Coalition, and the Second Amendment Foundation, among others, challenging the new surcharge, the new tax targeting firearm and ammunition purchases in the state of Colorado. Let's break down this major lawsuit. Excellent complaint here. There's some really important stuff that I want to connect the dots for you to make you the smartest person in the room involving the legal strategies associated with this complaint. Let's talk about it when we come back. Hey folks, I'm Mark Smith, host of the Four Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice, the Second Amendment in America. Thank you, 2025 Gundies Awards. I appreciate all of your support in the Second Amendment community. All right, we have a major lawsuit here. There's a lot to learn from this, involving a legal challenge under the Second Amendment to the brand new tax of 6.5% excise tax targeting the retail sale of any firearm or firearm precursor part, presumably that refers to frames and receivers, as well as ammunition, enacted by the state of Colorado. Now, just as a reminder, as I told you before, because the anti-gun movement has infinite amounts of money from their billionaire class and their multi-millionaire class of donors, but they don't have a lot of places to spend it, because spending money at the federal level is, what are you going to do? Trump's not going to talk to you. And the number of states that have become full-blown Second Amendment supporters has grown dramatically, where we have almost 30 states that are permitless carry alone. And the Supreme Court is relatively sympathetic to the Second Amendment. Of course, we want them to be more aggressive, but the point is there's not a lot of places for the anti-gun movement to turn. So as I pointed out, as a consequence of this, they are laser focused on those handful of states in the country where the Democrats have that governmental trifecta, where they control the governorship, they control the House, they control the Senate and those state legislatures, and in many instances, they also control the courts of the state. Those are states like New York, New Jersey, Illinois, and yes, indeed, Colorado and Washington and so on, Oregon, California, Hawaii. So the reason why I mention this is because there's now a new law that's now been enacted in Colorado that says that there's going to be a 6.5% tax targeting the acquisition, purchase of any firearm or firearm precursor part or ammunition. Well, a lawsuit has just been filed over this law, which goes into effect, not ironically, on April Fool's Day, April 1st, 2025. Now, there's a lot I want to talk about this lawsuit. To begin with, I want to talk strategically about the groups that have brought this lawsuit and why I like what I'm seeing with this cooperation. And then I'm going to talk about the legal arguments associated why this new law by Colorado, this targeted tax on guns and ammo, is indeed unconstitutional under long-standing constitutional precedents. So to begin with, the plaintiffs in this case that have sued in state court, this appears to be in state court, the District Court of the Denver County in Colorado. Kind of interesting, because usually you'd see a lawsuit like this filed in federal court, but there must have been a strategic decision made to go to state court. Not unusual. I've seen that, sometimes you sort of pick and choose your venues. Plaintiff gets to choose the forum in most instances, and they must have made a strategic decision to go to state court versus federal court. And I think there's a bunch of reasons why that's the case, but this is what they've decided, so we'll just go with it. The organizations that have brought this lawsuit, there's several plaintiffs involved, but there's also some companies. Magnum Shooting Center of Colorado Springs, the Colorado State Shooting Association, the Firearms Policy Coalition, the Second Amendment Foundation, and the National Rifle Association. Now, I want to say, before we talk about the legal arguments made in this complaint against the state of Colorado and this tax, why I'm very happy to see these gun groups working together. There's several reasons why I'm happy to see the National Rifle Association, the Second Amendment Foundation, and the Firearms Policy Coalition work together. First of all, I don't know the financials of them, but I'm assuming it makes economic sense, because if you think about it, you've got one group of lawyers, and now you've got multiple plaintiffs that can each chip in to pay the lawyers, and that sort of reduces the cost for each of these organizations if you divide it up in some way as to how you pay the lawyers. So I think that is cost effective, number one. Number two, I think it's good to show unity among the Second Amendment movement, because the old saying that says you want to divide and conquer your enemy holds true. And it's good to see the Second Amendment community coming together to fight the good fight against the true enemies of America, as I see it. 3, there's sort of a strategic thing here, which is we've talked about if the Second Amendment plaintiffs prevail and they get an injunctive relief that says that the organizations and their members prevail and cannot be charged this tax. Let's say they get injunctive relief on behalf of the groups and the members. By having multiple groups involved, you have a lot more members of the Second Amendment community covered by the potentially favorable injunctive relief, right? You have all the members of the NRA, plus the members of the Second Amendment Foundation, plus the members of the Firearms Policy Coalition, plus the members of the Colorado State Shooting Association, right? See how that works? That increases the size of the protected class if you get some injunctive relief. So that is good as well. Beyond that, it also makes it easier to get and keep and maintain standing. Because as we've talked about before, under the United States Constitution, you have 3 branches of government. Article 1 deals with the Congress. Article 2 deals with presidential powers. I think you saw me probably talking about this on Fox News over the last week or two, right? And Article 3 deals with a judicial system that guarantees the existence of one Supreme Court and any inferior courts as created by Congress. And the reason why this is important is because if you look at Article 3 of the United States Constitution, it says that those federal courts can have jurisdiction over cases and controversies. And one of the essential characteristics of a case or controversy, which is an actual legitimate fight where a court has a basis to rule in one way or another and change the status quo in favor of one person against another, let's say, identify the rights of the two respective parties, rights and responsibilities. The more plaintiffs you have involved, the easier it is to have standing, because you need standing, meaning a plaintiff has to have standing, meaning a plaintiff has to have been injured or will be injured, to have standing, and to have standing, which is an essential characteristic of having a case or controversy, which is an essential component of having a federal court have jurisdiction over the issue. So it's very important to have enough people directly impacted in an adverse way on the plaintiff side of things, in this case of the Second Amendment plaintiffs against the state of Colorado, really, to make sure that you never lose standing, because if you lose standing, the case goes away because there's no jurisdiction for the court to decide it. And you never want to do that. That's always a bad idea. So I'm very happy to see these gun rights groups all working together. And I think this is a positive development that we should all be cheering for. Now let's turn and focus on the other critical part of this complaint, and that is the elements or the arguments on the merits of this unconstitutional tax. And it seems pretty clear to me, based on all the relevant law, that this targeted tax on the right to keep and bear arms is unconstitutional. And if you look at this complaint, which I'll try to put a link to it below in the description, that is clearly the case on multiple grounds. So to begin with, the first argument is just under NYSERPA versus Bruin. As you know, under Bruin, if the modern-day gun control law is implicated by the text of the Second Amendment, meaning there's an infringement of the right to keep and bear arms, the right to keep means to have, to possess, the right to bear means the right to carry. If there's some sort of infringement, which means to hinder, if there's some hindrance of the right to keep and bear arms, that is an infringement. And textually, the modern-day gun control law implicates the text of the Second Amendment, which means it's presumptively unconstitutional and unenforceable. And the only way that can be overcome is if the government can show and meet its burden, because the burden shifts to the government to show as a matter of historical practice, long-standing, well-established historical practice, a historical tradition, that indeed there is some exception to the textual right of the people to keep and bear arms. And the example I'd like to give is there's a historical tradition in America going all the way back before the founding to prevent people from using firearms to commit cold-blooded murder. So the right to keep and bear arms does not include the right to commit cold-blooded murder, but the way we know that is not from reading the text of the Second Amendment, it's looking at the history of America at the time of the founding. So in light of that, we then have to ask ourselves, is there any history of targeted taxation on the right to keep and bear arms? And the answer is no. We know a tax on the right to keep and bear arms is a hindrance, because if you make something more expensive, it hinders people's ability to exercise it. It may price people out of the market or cost them more money, but whatever it is a penalty. It's something that's detrimental, makes it harder. And as they say, and I'm happy to report this complaint points this out. The famous saying from McCulloch versus Maryland, an early Supreme Court case from 1819, it specifically says that the power to tax is the power to destroy. That's right. A power to tax is the power to destroy, because I can tax you 100% on something, and I'm now just destroyed that property right, or whatever it is. So here, the power of the state of Colorado to tax the right to keep and bear arms gives the state of Colorado the power to destroy, because they can impose some onerous tax, then no one would be able to exercise their right to keep and bear arms except maybe Elon Musk, right? So obviously, the question is there any historical precedent, well-established precedent of targeted taxes on guns and ammunition? The answer is no. The government's not going to be able to prove any of that. So even if you set aside the other precedents I'm going to get to in a minute, the right to keep and bear arms, there is no historical tradition at all that's well-established that says that Americans allow for their government to tax in a targeted way the Second Amendment right, the right to buy guns, the right to acquire guns, the right to acquire ammunition. That doesn't exist. And because that doesn't exist, the government will not be able to overcome its burden using history, right, to overcome its burden using history to somehow say that the text of the Second Amendment, the right of the people to keep and bear arms, shall not be infringed, does not apply here, and thus the burden on the government will not be satisfied, and this law should fall by the wayside just under Bruin. Now, beyond that, of course, there's also several Supreme Court precedents that say, and this is not even in the context of the Second Amendment, it just says, generally speaking, if the government has a targeted tax on the exercise of a constitutional right, it is verboten, it's not allowed. Now, the two examples I always like to give, because they're very clear, is the Minneapolis Star case that says that a targeted tax on ink used by newspaper publishers in the 1980s was unconstitutional in the Minneapolis Star case. Why? Because you need to be able to buy ink to print papers, and there's a First Amendment right to free speech and a First Amendment right to the freedom of the press. So the Minneapolis Star case applies nice and clearly here. Then, of course, you have the 1960 case, the 1963 case, I believe, of Harper versus the Board of Elections that says a $1.50 poll tax, a $1.50 poll tax on voting is unconstitutional because, again, there's a targeted tax on a constitutional right. And this complaint also cites to a 1943 decision, which we don't talk a lot about because it's kind of a little older, but it's still good law. That's Murdoch versus Pennsylvania, that deals with, I believe, Jehovah's Witnesses going door to door to solicit donations and whether or not a tax on them could be applied. And in Murdoch versus Pennsylvania, the Supreme Court in 1943 said, no, that's a no-go because, again, taxation of constitutional rights is verboten and not allowed. So that's the second way. I think the first way the plaintiffs here should win is because there's no historical tradition of taxing these rights under the Second Amendment Bruin analysis. The second independent way is just applying modern-day tax rules. You can't target tax constitutional rights, including Harper and Minneapolis Star, and now Murdoch versus Pennsylvania, if you want to throw that in there, from 1943. And, of course, just pointing out the very basic rule going all the way back to the time of our founding, 1819, early on, of McCulloch versus Maryland. This is the power to tax is the power to destroy. So if you let governments go out and tax these constitutional rights, you're essentially giving them the power to destroy, because if they can tax you at 6.5% per transaction, nothing prevents them from making it 60% or 600% or 6,000% and destroying your ability to acquire the right to keep and bear arms, acquire the gun, acquire the magazines, acquire the frames or receivers, acquire the ammunition to shoot them, and so on. So if you start to have to pay $1,000 a bullet, there's not going to be a lot of shooting and a lot of exercise of the right to keep and bear arms, obviously. So there you have it, folks. A very exciting development in Colorado. Unfortunately, Colorado is one of these states that is controlled by the Democrats, and all that anti-gun money is flowing to places like Colorado because they have nowhere else to go. So our overall victory on the Second Amendment, the trend is our friend overall across this great country, is good. And unfortunately, as pointed out before, because the Democrats and the anti-gun movement is deploying all their money in these handful of jurisdictions, which includes Colorado, includes Washington State, includes Oregon, California, Hawaii, and places where the Democrats control all of the state. Well, that's unfortunate. It's terrible for our friends out there in places like Colorado, but we have to fight the good fight and hope that eventually the courts do their job, which I'd like to see them do a better job and a more robust job and a faster job than they are right now. But this is the world we now live in. So with that said, I hope you enjoyed today's show. Make sure you follow me on X at 4boxofdollar. Don't forget to follow me on subscribe to both 4boxofdollar here on YouTube and on Rumble. I look forward to talking to you again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.